Hi, I'm Sylvia Mayer, arbitrator, mediator, and attorney located in Houston, Texas, serving as neutral in disputes all around the country. Thanks for joining me today for Mayer on mediation and arbitration. This is the fourth in the Breaking Up is Hard to Do 9-part series on dispute resolution for business divorces. Self-dealing, inequitable compensation, exclusion from decision making, usurpation of business opportunities, denial of access to books and records, disagreements over future directions, business failure, fraud, mismanagement. These are some of the common accusations in a business divorce, but each of these allegations boils down to one catalyst for the dispute: betrayal. Whether perceived or real, the sense of betrayal makes these disputes emotionally charged, and they have a cavernous trust deficit. So, how do we diffuse the emotions, bridge the trust divide, and move towards resolution? Well, in the context of arbitration, arbitrators use the structure to mitigate these challenges. There is a formal construct setting guidelines, parameters, deadlines, and ultimately a final hearing date. The process culminates in that final hearing where each party has the opportunity to be heard. In mediation, the trust deficit looms large because mediation is about the parties reaching an agreement. Mediators have a lot of tools in their mediator toolbox to help bridge the trust divide. Time. Allowing parties time to safely share their experience and emotions is critical to these mediations. Parties often need to be heard, validated, and supported before they can move beyond their pain and explore options for resolution. Common ground. Parties locked in a dispute tend to focus only on their differences. As a result, they often miss the common ground. Taking time to seek out and identify and highlight the areas of agreement may help to rebuild some of the lost trust and connection. Connection. At the start of their venture, the co-owners shared a connection, a family connection, a friendship, a shared vision, something else. In some business divorce mediations, once they have had a chance to process their negative emotions, sometimes the parties become nostalgic for the connection they once had. Once remembered, this shared connection may help them shift towards finding a path to resolution. Reciprocity. Deeply ingrained in nearly every culture is the rule of reciprocity. Those who give a benefit are entitled to receive a benefit in return. Time and reciprocity need to be sequenced. The rule of reciprocity is most effective once each party has had time to process their emotions. The back and forth and back and forth and back and forth of mediation is actually reciprocity at work. Receptivity. To pivot from entrenched positions to exploring interests and options for resolution, parties need to become receptive. Receptivity is being open to hearing and considering different views, options, and opinions. Receptivity takes time to share, time to be validated, time for empathy, time to process, time to find the common ground, time to engage and in reciprocity and reconnect. Once all parties are receptive, meaningful process can be made in finding a path to resolution. Thanks for joining me today. Please connect with me on LinkedIn or subscribe to my YouTube channel.